Well, thanks everybody for joining us this morning. I'm Luke Hook, the General Manager of Policy at the VFF. This morning is our first seminar on the new EPA laws, presented by Jane Hall and Sophie Westland from Ashurt Lawyers, who the VFF have partnered with to deliver these seminars. So just letting you all know that the meeting today is going to be recorded so that we can then package that up to supply to you and all of our other members. So if you prefer not to have your face or your voice on any recordings, just turn your video off and you can put any questions in the chat. Also letting you know that when we distribute the recording, we'll also send out a fact sheet that has a bit of a summary and some information on it that you can provide to your employees or use as a reference. So I'll introduce Jane Hall and Sophie Westland.
Excellent. Thanks, Luke. Morning, everybody. Great to see you. I would like to start by acknowledging the traditional custodians of the land on which I'm presenting, and unfortunately, because of these troubled times we're living in, the traditional owners of the land which Sophie's presenting from and that you're all participating in. In an ideal world, we would have loved to have all sort of sat around a table and had a real workshop style presentation today. So I really do encourage you, we've got an hour and a half. We really do encourage you to pipe up with any questions, either in the chat box or, unmute yourselves, sing out. We really do want you to get the most value out of the session today. And it's going to be much more entertaining for everybody, I'm sure, if we have a bit of a dialogue rather than Sophie and I just talking at you for over an hour and then opening up to questions at the end. So I guess to cut a long story short, don't be shy, pipe up if you've got any questions as we go along. If we can go to the next slide, Sophie, what we're hoping to cover today is a bit of a background about what is the Act that we're talking about, what is the cornerstone of these new laws that you might have heard people referring to. We'll look at some of the changes to the permissions, so the licensing, registrations and permits that you may or may not require under the new laws. We'll then have a brief snapshot about waste, noise, odour, contaminated land and pollution events. And then we're going to look at, well, if you, I guess, transgress, what does the EPA powers, what can they do in relation to any breaches of the Act? And then we'll have a look at some case studies, which will hopefully sort of generate the discussion around how this actually might work in practice for you guys in real life, so to speak. So the new Environmental Protection Act, this is, I guess, a milestone for us in that the Act that we were operating under before was the Environment Protection Act of 1970. And a good example of how that Act worked in practice for us practitioners was that people sort of described it as a house that had had lots of renovations, but there was never sort of a master plan and all of the bits kind of were there, but you might have to go through the laundry to get to the main bedroom because it was all just a bit of a shambles. So it's been really refreshing for us as practitioners to sort of have that Act thrown in the bin, and we've literally started again. And hopefully, if you need to sort of look at the Act at any particular time, you'll find it's much easier to follow and to find the things that you're trying to find. So the Act that we're talking about now is the Environment Protection Act of 2017, Victorian Act, and it stems from a complete review of the Environment Protection Authority and the ability for our laws to deal with the environmental issues that we're facing today, but also the environmental issues that we're sort of seeing emerging. And one of the big things for the EPA was that previously it was sort of the big ticket sites with licenses that they were easily able to control. Whereas, as we're probably all aware, it's the cumulative little contributions that a lot of different operations give in terms of the environmental impacts. And so that was one of the big drivers for the new regime. And I'll come to the cornerstone in a minute. Just be aware that this Act was meant to commence 1 July of 2020, but was apparently delayed due to COVID, and it started 1 July of this year. Frustratingly, I guess, even though this has been a long time in the pipeline, we're sort of finding that the EPA still feels in some areas as not being 100% ready. So a lot of guidance is still coming out as we speak. So I guess the other thing that we should note is that what we say today won't be, necessarily the case in another 4 months' time. So I guess keep looking at the EPA's website for things that might be relevant to you, and I'm sure that Luke and the VFF will sort of help you stay on top of that. But the EPA is still releasing quite a lot of guidance. The slide that you've got in front of you really is something that we're not going to go through now speaking to. It's kind of like a cheat sheet that you'll be able to look back when you get the recording, but also the fact sheet that you'll be able to sort of pin up in your office or wherever you want to put it will basically cover that information. So just be aware that we've tried to sort of summarize what the big ticket changes are on that slide. And hopefully by the end of the presentation, you'll sort of be completely on top of all of those changes. So if we turn now to the general environmental duty, I might just pause there. Does anyone have any sort of preliminary questions about the Act or why we're talking about a new Act? No, I'll keep going then. So the general environmental duty is called the cornerstone of the new laws. And the reason why I touched on before, instead of the EPA being able to control and target and really limit the activities of licensed sites, those big, they used to be scheduled premises that needed a license, this general environmental duty applies to across the board, basically. So everybody in Victoria that's undertaking an activity, and we'll come to who this duty applies to in a minute, but everybody that's undertaking an activity has an obligation to implement reasonably practicable steps to minimise risks of harm from pollution or waste to human health or the environment. And so instead of the EPA really waiting for there to be environmental harm, so before we had a number of offences like pollution of waters, pollution of atmosphere, pollution of land. So what would happen is that there would be an environmental incident, and then those provisions would have been contravened, and then you would be prosecuted or be issued with a pollution infringement notice by the EPA because there had been harm to the environment. Now, instead of needing there to be an environmental incident, the EPA is looking at how are you managing risk on your farm? Are you either eliminating risks so far as reasonably practicable, or if it's not reasonably practicable to eliminate them, what are you doing to reduce those risks so far as reasonably practicable? So it's a very different approach to environmental regulation in Victoria. And you'll probably see that there are some pretty key terms there that we'll unpack a bit more in a minute, like what does reasonably practicable mean? But I think the important thing to note at this point is that the fact that there has been an environmental incident is kind of irrelevant to whether you've contravened and committed an offence against the general environmental duty. It might be relevant in terms of the EPA being able to say, well, if you'd done X, this wouldn't have happened, and therefore that's an argument that you haven't implemented reasonably practicable steps to control that risk. But the fact of the incident is irrelevant, and it's all looking at whether you have considered what the risks are from your operations, thought about whether there are mitigation strategies that you can implement in order to reduce those risks, then changing your systems or strategies to implement those risk mitigation strategies. And as well as that, educating the people that are working for you as to how they can reduce those risks as well. So it's all very well to sort of go through this risk analysis and sort of do all of the hard work and then put it on the shelf and then sort of forget about it. But really, it's going to be as important about how it's actually implemented on the ground and how you educate the people that are working with you as to how they too are going to implement those reasonably practicable steps to eliminate or reduce the risks as far as reasonably practicable.
So I think the key thing to be aware of is that the EPA can come onto your farm now and take a look at your operations and look at and say, have you got an effluent management plan? Okay, show it to me. What does it do? Are you implementing it? How they might look at your chemical storage. How are you storing it? Is it in an abundant area? Should it be? When you do your wash down, where does the runoff go? Are you aware of where it ends up? How is it being collected? Is the system that you have in place being repaired? Are you inspecting it? How often are you monitoring it? If I went and spoke to a staff member, would they know where the management plan is? Would they know what it means? Would they know who to call if there's an incident? How often are you testing the controls that you have in place? How often are you calibrating the equipment that you have at the site? All of these factors go into minimising risk, and they don't need to know that something has gone wrong. It's not a trigger anymore that there's been an incident. They can come on and ask these questions and form the view that you're not taking all reasonably practicable steps without anything going wrong.
We've had a question there about EPA having to follow farm biosecurity before entering. The EPA does have broad powers to enter sites to investigate, for example. I would have thought that they would have to comply with sensible directions, OH&S directions, as well as obviously as the environmental regulator, they don't want to create environmental issues. So I think it would be completely within your rights to say, well, I can't stop you coming in, but if you were sort of giving them reasonable
inspect their tyres and inspect
requests,
their shoes and
reasonable requests to as to how they enter to minimise risks of harm, and I guess it demonstrates that you're aware that you've got a duty to minimise risks of harm from spreading of seeds or other pathogens on people's tyres and shoes. Then absolutely you would draw that to their attention when they're entering the farm. So turning to the next slide, who does the general environmental duty apply to? And it applies to any person who's engaging in an activity that may give rise to risks of harm. And that includes people conducting, undertaking, managing, or people in control of an activity. So Sophie and I could spend a whole 45 minutes talking about, well, when you've got subcontractors on site, to what degree are you still in control of that activity? So that, there's a lot to even unpack in that. But I guess the point is that it's very broadly drafted to capture people undertaking activities. You cannot just say, okay, well, if I've subcontracted to somebody else to do something, it will depend on the factual circumstances as to whether the EPA thinks that you are still in control of that activity. And you can see in the middle box that activity is also defined very broadly. It includes storage and possessing wastes or other substances. So I think the takeaway is you need to assume that you're covered by this general environmental duty, and that the mere fact that you're trying to sort of get other people involved in your activities on the farm via contracting doesn't mean that you will not have that duty as well. The other thing to note is that if you've engaged somebody to, for example, build an effluent management system, so this is what we call sort of an upstream duty holder, that contractor also has a general environmental duty in terms of designing that system to minimise waste or pollution from, for example, entering stormwater arising from the normal operation of whatever it is that they've been asked to design or manufacture. I guess the thing to note about that is just because somebody else might have a general environmental duty doesn't mean that you as the farmer also doesn't have a general environmental duty. Now, the scope of that duty is and what you need to do to show that you're complying with that duty will be different depending on where you are in that chain. But just be aware that a number of different people can all have a duty, which might be slightly different, but the fact that one person has a duty doesn't mean that you lose your duty.
There can be some overlap.
Yes, there can be overlap. So there are some helpful things in the Act itself as to, well, what is it that you actually have to do on the ground to comply with this general environmental duty? So the things it talks about is that you need to use and maintain plant, equipment, processes and systems in a manner that minimises risk. You need to use and maintain systems to identify, assess and control risks of harm and evaluate the effectiveness of the controls that you can implement. You need to use and maintain adequate systems to ensure that if risk of harm actually arises, that you've got a system in place to minimise the harmful effects. So in other words, if something goes wrong and there is harm, how do you minimise the risks or reduce those so far as reasonably practicable? You need to ensure that substances are handled, stored, used or transported in a manner to minimise risks, and provide information, instruction, supervision and training to a person engaging in the activity to enable them to comply with the general environmental duty. So I think we've really touched on all of those things already. It's about the systems that you have in place to identify, manage and reduce risk, as well as ensuring that other people know what part they have to play in that task as well. In terms of what reasonably practicable means, well, obviously that depends on the facts of each case and the state of affairs at the time that the risk arises. So there's sort of not one size fits all analysis that we can give you, about what reasonably practicable will mean. But the factors that are relevant to that analysis, again, these are set out in the actual Act itself, is, well, what's the likelihood of the risks eventuating and what is the likely degree of harm that would result? So a lot of you might have done risk assessments before where you've sort of got green boxes through to red boxes where you sort of line up, well, if there's a low likelihood and low risk of harm, then it's sort of a green box, but flowing through to, well, this is likely to happen and if it happens, it's going to be really bad, you go through to your sort of red boxes. So those two sort of first things on the slide really shouldn't be that much of a surprise if you've done risk assessments before. The other things that are relevant though is, well, what did you know about these risks of harm and the ways that you can go about eliminating those risks of harm? And the EPA talks about this state of knowledge, and the state of knowledge requires you to sort of have regard to industry publications, EPA publications, best practice guidelines and other things that are available to sort of educate yourself about, well, this is the risk, how do I manage it to the best of my ability? And the thing to note about that, Luke's got his hand up, yes.
Jane, I was just going to ask, so the EPA aren't designating a new series of paperwork that farmers have to abide by. These are likely things that farmers are already doing and already completing on farmers just as part of their business, but it's just governed by a new duty. Is that right?
Yeah, look, I guess it depends. Without knowing what everybody is actually doing on the ground, I'm assuming that people have risk assessments and they have a risk register that says, well, after I've implemented these mitigation measures, the risk becomes a low risk, and you sort of update it regularly. And yes, so I'm assuming that is what you're already, your members are already doing. I guess the point is though that in the past, the EPA would have to wait for something to go wrong before it can do anything. Whereas now it can come in and say, well, we don't think you're managing that risk in a way that's appropriate or sufficient. So I think it probably makes it even more important to have your risk register up to date, correct, and have that paper trail and that sort of due diligence that you can say to the EPA if they do enter the site, well, this is how I've assessed my risks, and this is what I'm doing about it, and this is how I'm reviewing it, and this is how I'm telling my people, my employees, about how they need to reduce. So the fact that you're here at this session today is part of that story for you guys as to getting on top of what's going on, what you need to know, what you need to do. So I think probably, yes, it's not a dramatic change necessarily, but bear in mind that you need to be able to prove to the EPA that you're doing these things now.
And I think it's important even just to talk the language. So reasonably practicable doesn't mean that you have to do every single thing that's possible. It is what is reasonable having regard to the knowledge of the harm, but the availability, suitability and cost of eliminating or reducing those risks. And we are encouraging our clients to document sort of bigger risk decision making and document it using this type of analysis that the EPA is now going to be more familiar with, or that's the lingo that they're going to be using. And so if you're using the same lingo, you're already going to be a step ahead.
Yeah, and I think that the sort of the whole the vibe of the EPA's publications in this regard is that they're expecting you to react proportionally. So if you've got a major risk and really bad things can result, they're going to expect you to do more. Whereas if you're talking about a smaller risk that really the degree of harm that might result is not great, then they're not going to expect to see as many controls around that risk. So just bear in mind, am I acting proportionally, having regard to all of those factors on the slide? Am I acting in a proportional way to manage my risks? So does anybody have any other questions about the general environmental duty? No? Okay. So I don't want to confuse you at all, but just be aware, and this is sort of an aside really, it's just to make sure you're aware of what the EPA can do. But because this is a really big change for how the environment is regulated in Victoria, the EPA has inserted a transitional material harm offence into the Act. They're thinking it will last for 2 years, so 2 years from 1 July of this year. And instead of prosecuting people for breaching the general environmental duty, so in other words, instead of looking at whether you're managing risks effectively or not, they do have the ability to prosecute if there has been an incident that causes material harm. So it's kind of preserving what we're used to under the old Act for a period of 2 years. And the EPA will have, I presume, a choice. We're not quite sure how it will go about dealing with the two options, but presumably they will have a choice to prosecute someone if there has been material harm, which is, you can see there, costs in excess of $10,000 to prevent or minimise or clean up the environmental incident. So not a very high threshold, but be aware that they do have this choice for 2 years. And it's kind of just, I guess, preserving the status quo. And they might be more minded to sort of pursue people under this offence rather than a breach of the general environmental duty while people are getting used to this new regime. So that's probably all I wanted to say on that. I don't want you to get hung up on it. It's not going to be around forever. It's kind of a stopgap measure while people get used to this general environmental duty. So any questions on this transitional material harm offence? No? Okay, we'll turn to some permissions and I'll hand over to Sophie.
So there is a new permissions regime in place. And by that, I mean that there are new types of approvals or authorisations that were not previously under the old Act. So you still have your licenses, and they're for the high risk activities. They're now called operating licenses, but they are in effect the same thing, and they're at the top of the pyramid for those who can see the screen. But now there are also additional approvals that are called permits and registrations, and they are for your medium and low risk activities. So what this means in practice is that more activities are now going to be regulated. So where previously the EPA only looked at high risk activities, so that's, you know, operating the farm in general, there are now permissions for what they call low risk activities, which are generally defined with reference to, say, the volume of waste that's being undertaken or where the waste is being used. So with respect to, you know, animal industries, waste that is going not solely to land requires a license, which is the case under the old Act. But now if you are using the waste solely to land, you now need a permit because that is considered a medium risk activity, whereas previously you may not have needed a approval for that activity. Another example of registrations is for a low risk activity, waste tire storage of less than 4,000 EPUs now needs to be registered as an activity, whereas previously it was not regulated. So what this means is that your permits and registrations will have certain set conditions. And so registrations, low risk, you're meant to just be able to apply for a registration and then it's automatically granted by the EPA after 30 or 40 days. Your permits will need to be applied for, and that's a slightly longer process. And it's meant to reflect the risk that is presented by your activity to harm. So that's a pretty significant change. And the key takeaway is that you need to have a look at the regulations and determine whether an activity that you are undertaking on your farm, such as the storage of low volume waste that previously wasn't regulated because it didn't need a license, you might now actually need a permit or a registration for that activity. Now, obviously, like the old system, there are some exemptions in place. And so that will be relevant to your consideration. For those who can see the screen, there is a table on the slide that goes through some of the examples of permissions that are required. So, you know, sometimes the use of biosolids and reclaimed wastewater might need a permit. There are some exemptions in relation to certain scenarios. For registration, some small organic waste processing now needs to be registered. Temporary storage of certain wastes will need to be registered. So it's important to sort of have a look at the new permissions regime and determine whether any of your medium to low risk activities will now need a permission. In terms of licenses, if you had a license under the old regime, that will translate into an operating license under the new regime and you shouldn't have to do anything. However, the EPA does have a time period in which it can update license conditions. And so it's released some guidance about what those conditions might look like. So the second key takeaway about permissions is that if you had a license, your conditions might be updated if they haven't already. And like we know from experience with our clients who are running high risk sites, they got new licenses with updated conditions on day one. So July 1, they were sent out new licenses that basically had the updated conditions. I can't say that the EPA has done that for every single license holder. They might have had to take a risk-based approach and did it for the high risk sites first. But there is guidance on what those updated conditions might look like. And it's important that you're aware of what those changes might be if you aren't already. There has been a question about who farmers ask if they are unsure what they need. That's a very good question. There is some guidance online from the EPA, but we would encourage you to reach out to Luke to ask those questions. But also Jane and I are here if you want to send through any more specific questions, we'll try and answer them on this presentation, but we're also, we will look at them afterwards and come back to Luke with some answers that he can distribute to different farmers. But the regulations, I mean, it's not, you can open up the regulations and go to the right schedule and have a look at the activities that are being prescribed as permit activities or registration activities. So that's what we would try and encourage people to do, but understand that, you know, even after looking at the legislation, you might have questions. Ring the EPA. We're certainly doing that. We've got a number of queries that we've sent to the EPA about various, particularly waste is a big one that people are asking a lot of questions about. So that's what we would encourage you to do.
And can I just say on that, sometimes the response that you get first up can sometimes not really answer your question, or it's not sort of hitting the nail on the head. It's okay to go back to them and say, well, you haven't actually answered my question. This is what I wanted to know. And if you are, like, I'm thinking of an example, we had to go back sort of 2 or 3 times and then we got the information that we needed from the EPA. So don't be scared about pressing them to, you know, if you're not getting the information that you need. I think, Luke, you sort of unmuted yourself. Did you have a comment to make in relation to that question?
No, I was just going to encourage people to send questions through to myself or Lyndall. I'm sure there's going to be common questions from producers, so we can try and get standard responses from the EPA. And if you need individual advice from them, we can link you up with the right person there.
Sophie, there's another question here. What's the process for applying for permits and registrations? Can these be applied for online? And I think the answer is yes.
Yeah, I personally haven't done it, but most of the way that the EPA is operating at the moment is that everything's online. You might have to, there will be a form. They do love a form, but the registration is meant to be automatic. So as soon as you basically register, you should get this sort of, you know, almost like an auto reply saying, you know, your activity has been registered. Permits will be a little bit more of an approval process to undergo, but yes, it can be done online is our understanding.
And the registrations, the idea of this, I think, is more about the EPA knowing who's doing what rather than necessarily controlling it very closely. So I actually haven't seen a registration and what these standard conditions are going to be, but it's more about visibility for the EPA about what the issues are that are being managed in Victoria. The other thing just to note is that, I don't know, we use the term EPU in terms of waste tyre storage, which is equivalent passenger units. So if you think of a normal car tyre is 1 EPU. So if you've got tractors and big equipment on farms, they're going to be potentially hundreds of EPUs for just 1 tyre. So please don't think that 4,000 is 4,000 tyres, because it definitely depends on how big those tyres are. And again, in the regulations, there's sort of a table that says, well, if it's this tyre, this is what the EPU value is. So just be aware of that potential trap.
And Jane, just clarifying there that the tyre storage also refers to the use of tyres for on silage pits and that type of thing. So it's not just storage in a shed or in an open confined space. It's also tyres that are utilised on farm.
Yeah. So does anyone have any permission questions that we haven't dealt with already?
Okay, so now we're going to talk about noise. So the thing to be aware of with respect to noise is that there are basically 3 changes. So,
Sophie, we seem to have lost our.
So there are basically 3 changes. So there are new values, and these are what in the old system we called beneficial uses. And these are areas that the EPA seeks to protect a little bit more specifically. So if you think of sleep being a beneficial use, there are specific requirements in the Act that seek to protect sleep. Because people obviously don't want to have noisy operations at night. And so the new values that are being protected are childhood learning and development, and human tranquility and the enjoyment of outdoors in natural areas. And so what it means is if you're undertaking operations near some of these new protected values, then you might be subject to slightly different noise limits. So it's important to sort of, if you are near those areas, to be aware of that. There are new instruments, and by that we mean some of you may be aware that under the old system we had the SEP N1 or the NERV 5 for regional areas, and they were just sort of the lingo that we use to refer to the documents that set out what noise limits are in place for a particular activity in a particular area. So they divided it between Metro Melbourne and the regional areas. You will not see those references to those documents anymore because they have been replaced by a new document, and it's called the Reference Standard and the Noise Protocol. And everything has been sort of combined or merged into these new documents. But if you talk to, say, an acoustic expert, the methodology used to come up with noise limits and the actual noise limits themselves are the same. It's a bit of a rebadging and a consolidation to hopefully make the system a little bit more simple.
Sophie, we haven't got the right slide up.
It seems to, can you see it now?
No, we've got odour.
Really? Sorry guys, that's not what is happening on my screen. I might just quickly try it again. I'm not sure what happened there. What about now?
Yeah, we've got noise, but we can see the thumbnails down the left as well.
The thumbnails?
Well, the preview, slide preview and speaking notes.
That's also not happening on my screen. I'll try again. Sorry guys, not sure what's happening. Just not. What about now?
Perfect.
Sorry,
don't
honestly.
touch it.
Yeah. Sorry, and so new instruments, everything's been consolidated. SEP N1, NERV 5, not relevant anymore. Reference Standard, Noise Protocol are now the new lingo. But the biggest change that's happened is that there is now two new, what they're calling controls, which are effectively like offence provisions that say you cannot emit unreasonable noise from commercial, trade and industry sources, and you cannot emit aggravated noise. So there are two sort of new types of offence provisions where the EPA can say, well, we think that that's unreasonable noise, and we're going to slap you with a fine, or we're going to take some form of enforcement action. So obviously what is relevant there is to understand, well, what does enforcement noise mean? And what does unreasonable noise mean? And what does aggravated noise mean? And unreasonable noise will be considered in light of the volume, intensity, the duration of the noise, the character of the noise, the time, place, and other circumstance in which the noise is being emitted, and anything that they might generally consider as being unreasonable with respect to noise. And then aggravated noise is like the next step up, and it's sort of where you're 15 dBA above the limit, or you're in excess of 75 dBA. And when I say dBA, that's like the decibel limit that acoustic noise is measured by. So that's the aggravated is where you've really gone significantly above your limit. So it's probably the unreasonable noise offence is going to be a little bit more relevant to everyday operations. But with respect to farming, it's important to understand that there are some exemptions. And so what Reg 117 says is that when they're considering or undertaking a noise assessment and they're considering what is unreasonable, they cannot take into account noise from the sources identified on this slide. For those who can't see it, it means noise from equipment used in relation to an emergency, noise from construction activities, noise from mobile farm machinery, except for maintenance activities, noise from scare and anti-hail guns and firearms, noise from livestock on farms or sale yards, noise from lawn mowing, noise from large fans used to circulate air over a wide area where crops such as citrus, stone fruit, or vines are grown. This is not the full list of exemptions. We've specifically picked these ones as being relevant to the agricultural sector. But that's important to understand that whilst there are these new controls, there are these new offence provisions, when the EPA is considering whether noise is unreasonable, it cannot take into account noise from these sources. So I'll just stop there. Is there any questions about noise? No? Okay, well, we're going to go on to odour. So odour is obviously an issue that arises from a variety of different activities. Common activities that will cause odour is, waste treatment, composting, things that are fermenting. In terms of farm activities, obviously manure, chicken, poultry, rotten eggs, rendering plants, tannery and skin and hides. All of these things can create odour. And why the EPA cares about odour is obviously it might affect the amenity of nearby residents. So we often find that odour is more likely to be an issue where you've got operations that are in proximity to residential areas. From an agricultural perspective, it's more likely to be an issue where there is farming in sort of peri-urban areas. So, if you think about the outskirts of Melbourne, areas in Werribee, things like that, where you're likely to have the community that will identify or report odour issues. If you go to the EPA website, what the EPA encourages people to do is keep like odour diaries, and they've got like an odour wheel that says what does it smell like, when did you smell it. Odour is more likely to be smelt in the early mornings and late at night when it's affected by the weather. And so landfills often have a big issue with odour. It's why the EPA, what you might see is that people complain about headaches, having certain physiological reactions, so dry reaching, but they also might not want to be outside. So all of these things that mean that the EPA sort of care about the odour that might be emitted from operations that are being undertaken.
Can I also interrupt there? Sorry, Sophie, is as two of the themes is that all of the Act is about protecting human health and the environment. And the other thing to note is that human health is specifically defined to include psychological health. So if people are, they don't necessarily need to be physically impacted by odour. They can say, well, living here, it's just, I'm stressed and it's creating issues, psychological issues for me and my family, and we're all upset about it. That in theory could be enough. So just bear in mind, it doesn't have to be a physical reaction that they're having.
Yeah, very good point. And the EPA has recently released a report with respect to a landfill that we've been working on, and they've said exactly that thing. They've said when humans expect that odour is harmful, our bodies can react as if that odour is harmful. And so that's where we start to see the psychology can start to drive some physiological responses as well. But they also say the human nervous system has developed to alert humans to avoid bad smelling things. So our bodies are trained to actually react in a certain way to protect us. So the way that this is regulated is that it's sort of three ways. So it's through the GED, which is what Jane talked about at the start, the General Environmental Duty, which requires you to take reasonable steps to minimise the risk of harm. Harm is defined to mean something that has an adverse effect on the amenity of a place or a premise that unreasonably interferes with the enjoyment of that place, or it can mean a change to the condition of the environment, so to make it offensive to the senses of human beings. So the definition of harm really does talk about things being offensive to the senses, which is clearly odour. So the EPA might use the General Environmental Duty to make sure that you're taking reasonably practicable steps to minimise the risk that odour is being emitted into the environment and into a place that might be affecting other people. The other way that they might regulate it is by through the pollution incident controls, and we'll talk about pollution incidents a bit later. But it's important to know that a pollution incident might give rise to odour. And if that's the case and it does cause harm, then the EPA might come along and say, well, you've just, spilt all this effluent in a way that was not controlled. It's caused the release of certain air emissions that have an odour impact, and that's a pollution incident, and we can take certain enforcement action. The third way, and probably the more common way, is that often a lot of activities will have a license condition that will say offensive odour must not be emitted beyond the boundaries of your premise. If that does in fact occur, then you've breached your license condition. So, but this is a feature of the new legislation, is that there's multiple angles through which the EPA can seek to regulate and enforce activities. Odour is just one example that there is 3 potential pathways that the EPA might say that we're not happy with the way that this has occurred, or there's an impact that's arising from your activity.
And the question, it made me chuckle. I'm sorry if you saw me laugh. What safeguards are in place for a farmer if they have a vindictive neighbour? And the reason I laughed was because this is like the question that is so hard to answer, because we've got clients that you potentially have an ex-employee that lives close by, and any chance that disgruntled person can basically keep reporting to the EPA odours. So it's definitely a problem, and I'm sort of laughing because I was thinking, I hear your pain, because we've got lots of clients in that situation. The answer is that really there aren't any safeguards, so to speak. Clients have had sort of odour, I guess, checklists that they do. So if there's a complaint received, they will immediately go out with a checklist to say, okay, well, and they have they call them? They call them special noses or something. They've got people actually specifically trained on site, calibrated noses, I think they call them. And they go out and they sort of walk the boundary. They see what they can, well, they don't see, they sort of smell what's being generated from the site. They take a log of, well, where's the wind blowing from? Are there any sort of plant upset conditions that are occurring at the time? In an attempt to sort of get some documentation behind them as to whether these complaints are actually able to be verified or not. Because
so weather conditions are important, and identifying what activities you were undertaking at the time that the complaint was purportedly made, because often we find that clients will get a complaint at, say, 10 o'clock in the morning, and they'll say, no, there were no operations on site at 10 a.m. Or they might say, oh, the only thing we were doing is a clean down, and clean downs might not be the thing that they think is actually the most odorous. In more extreme cases, clients might be forced to sort of do air emission testing to sort of understand what volatile compounds are being emitted into the air from their operations. There is an Australian standard with respect to odour. It's called Stationary Source Emissions, Part 3, Determination of Odour Concentration by Dynamic Olfactometry. So they have tried to, there is maybe some science that you can refer to with respect to odour, but unfortunately, as Jane was saying, from a recipient perspective or a neighbour's perspective, sometimes the perception of the odour is what they're actually complaining about, and that is particularly difficult to manage. But if you've got that evidence behind you of what activities were being undertaken, what were the weather conditions, which way was the wind blowing, was it early morning, was it late at night, was it still, was there cloud coverage, you, at least when the EPA says, what have you done to verify the complaint, you can say you've done X, Y, Z.
And I think, stakeholder management as well. So communicating with that person as best you can. I hear you, a lot of the time it's kind of feels like a lost cause, but if you can sort of demonstrate again to the EPA that you're responsive and that you're taking the complaint seriously and that you've done all of this work to establish whether there's a problem or not, that will put you in good stead. I think one of the hardest things about odour is it seems like it's a very subjective thing, so that, what's offensive to one person is not offensive to somebody else. So I think, Sophie, there's going to be some guidance issued by the EPA to try and help people make that call as to, put some parameters around deciding if something's offensive or not, because that's one of the difficulties, that yes, you might be able to smell it off site, but is it actually offensive is one of the hardest questions to answer.
So publication 1883, guidance for assessing odour. It's been referred to by the EPA, but we haven't seen it being actually published yet. So it's just one to watch out for if you do have operations that are particularly odorous, or you do have a cantankerous neighbour, which can be frustrating. Any other questions about odour? Because I will move on to waste. No? Okay. So waste. Waste is a particularly significant change, I guess, in a lot of ways. The waste system has been given an update. The language that we use to describe waste is changed. And so if we look at the screen, the 3 new terms that you need to be familiar with are industrial waste, priority waste, and reportable priority waste. And looking at the buckets on the screen, so industrial waste is the general catch-all term for all waste. The definition means waste arising from commercial, industrial, or trade activities, or otherwise waste that's been prescribed by the legislation to be industrial waste. It includes things such as untreated timber, including sawdust, manure, end-of-life vehicles. And it's the biggest bucket because it also includes priority waste and reportable priority waste. And we're going to talk about the duties next, but it's important to understand that industrial waste is the collect-all, and that's why it's been shown to include all 3 buckets. So the middle bucket is priority waste. So that's your what we'll call maybe medium risk waste. It includes things such as industrial wastewaters, some biosolids, timber treated with hazardous substances, some industrial wastewaters. Now, there's a whole sort of process to classify waste, but in short, there's a schedule in the regulations that pre-classifies a number of substances and compounds as either priority waste or reportable priority waste. So if you go to Schedule 5, there are these columns. You can sort of search for substances that you might have on your farm, and you can look at, okay, has this been pre-classified as priority waste or reportable priority waste? If it doesn't appear in the schedule, then it falls within the general catch-all industrial waste. If it's identified as reportable priority waste, that's the highest risk waste. So it's the smallest bucket because generally speaking, you know, there's not as many of the high risk hazardous substances. And they're, you know, things like acids, pesticides, herbicides, tannery wastes, highly odorous organic chemicals are all in the reportable priority waste buckets. And they have particular duties. So the first step that you've got to think about under the new legislation is, okay, what waste do I have on my farm? How would I categorize or classify that waste under the new system? Can I go to Schedule 5 and find the substances that I'm dealing with on a day-to-day basis? How are they categorized? Now, there is some helpful guidance from the EPA about, you know, what were my waste codes under the old system? How do they translate into the waste codes under the new system? So there's a document with effectively 2 columns that helps you understand, you know, what was it under the old, what was it under the new? And it also shows you that there are some sort of slight changes. Certain categories that were 1 category before might now be 3 separate categories. And then it will tell you, has it been pre-classified as priority waste or reportable priority waste. Now, if your substance isn't in Schedule 5, then there's a process that you have to go through to then classify the waste, and it requires you to sort of refer to a subsequent protocol for assessing the hazardous substance of that waste. And it does cross-refer to the Australian Dangerous Goods Code. So if you are familiar with the ADG, then that will help you to classify some of your waste if it hasn't been pre-classified. So why I say that it's particularly important to understand what waste you are dealing with is because that then feeds into the new duties that you have under the legislation. And these are new positive duties that were not in the old legislation. So
can we just pause there? It looks like that we might have a question or a comment if you go back 1 slide.
Oh, on the old slide?
Sophie, I just had a question. So acids, pesticides, herbicides are all things that will commonly be stored and used on farm. So when do they become a waste?
When they're unwanted or surplus,
Discarded or surplus to needs. Yeah. So there is
Yeah.
a definition of waste in the legislation. It is particularly broad, but if you think about it in terms of what James just described, surplus to needs, unwanted, discarded, they are generally speaking what we would refer to as waste, but there is a definition in the Act.
Yeah, so if a farmer is storing, using, and then disposing of those products appropriately, they won't come into conflict with a reportable priority waste.
So why it's important to understand what the waste is, because it feeds into the duties. So the reportable priority waste duties, specifically for that high hazard, is more about transporting and tracking waste. In terms of like chemicals, there obviously are guidelines about how they should be stored, how they should be disposed of. So they'll have to, if you're disposing of a reportable priority waste, it has to be tracked when it's transported, and it has to go to a place that's authorised to receive it. We've had some questions about triple rinsing of containers. So if you've got a container that was previously had a reportable priority waste in the container, but then you've obviously used the chemicals in accordance with the requirements on your land, so you've now basically got an empty container. What is that container? Is it just plastic, or is it plastic that's been actually has residue of reportable priority waste? And there used to be some guidance about triple rinsing. So if you triple rinse the container in accordance with the guidelines, then basically the EPA is satisfied that you've gotten rid of the residue reportable priority waste, and it's now effectively just plastic. That's how we understand it to be the case now, but we actually are seeking confirmation from the EPA about that type of things, because guidelines that were previously really helpful about this waste and how things can be stored have not all been transferred over to the new system. Does that answer your question, Luke?
Yeah, I think so. I think it's just important difference to note.
Yeah, so another way of looking at it is when you're storing or using the product, I'm not going to call it a waste, when it's actually something that is valuable and you are storing it or using it, the general environmental duty will apply. So you need to minimise the risks of harm from to human health and the environment from using that, storing and using it. Then when you've sort of finished using it and you want to get rid of it, or you don't need it anymore, that's when it becomes a waste that you need to classify in accordance with these regulations. And there's the three different buckets. The reportable waste has, you need to comply with those duties, but also the duties for priority waste and industrial waste. And we'll come on to what those duties are. But I think you probably need to separate in your mind, you know, when is this actually something that's useful that I'm using, as opposed to when does it become that waste that this then kicks into the waste duties.
Luke, we've had a comment requesting some information be put in to a note about the triple rinsing. We can help you with that, because as I said, we're dealing with that for another client. So we've got to wait for the EPA to confirm.
Yeah, and that's going to be important for all the industries that we're presenting these webinars to. So we'll follow that up.
Excellent. So as I said, the reason we talk so much about what kind of waste you've got is because it feeds into the duties. There are different duties for different types of waste, but if you've got industrial waste, then it applies in the aggregate and all the duties. No. So if you've got, let's just make this more simple. If you've got reportable priority waste, the duties relate to, you've got a duty to notify of the transaction in reportable priority waste, and there are duties of persons transporting reportable priority waste. So this is the tracking system that under the old EP Act, we talked about waste certificates. Under the new system, there are these positive duties to track reportable priority waste, and there is a new waste tracking portal where my understanding is that the EPA has effectively tried to bring the tracking system into the 21st century. You should be able to do it online. I think they're developing an app to make it all easier for consigners, to make sure that the most hazardous waste that's moving around this state, the EPA knows about it. So if we talk about priority waste, the duties with respect to priority waste are that you've got a duty to manage priority waste, and you've got a duty to investigate alternatives to waste disposal. So that's an important one. And if you think about the whole concept of waste from a policy perspective, is they are trying to reduce the amount of waste that is going to landfill, because from a sort of practical perspective, we're running out of landfill space and it's not as good for the environment. So when they say you've got a duty to investigate alternatives to waste disposal, it's really getting a positive obligation on everyone in Victoria to say, does my priority waste need to go to disposal, or is there another way that I can recycle, reuse this waste? And so if you think about the waste pyramid that I remember from high school about reuse, recycle, that's really what this is getting at from a policy perspective, but it is a positive obligation. So you need to be conscious that these duties are now in place when you are dealing with priority waste. With respect to industrial waste, so that's the biggest bucket, there is now duties of persons depositing industrial waste. You've got to make sure that the waste is going to a place that is authorised to receive the waste. And there's also duties for people that are then transporting that industrial waste. But the biggest takeaway with respect to industrial waste is that you've got to make sure that when you're receiving waste, that you are a place that is authorised to receive it. And we can talk about a little bit what that means, but you've also then, if you're getting rid of waste, you've got to make sure that it's going to a place that's authorised to receive it. So what does it mean to be authorised to receive it? Generally speaking, it means that you've either got a permission in place, so a licence or a permit to accept the waste, or you've got an emergency authorisation, or you've got an exemption. Like, there's a reason why, yes, normally you'd need a permit, but in the circumstances of you're exempt from that requirement. Or, as is relevant to the agricultural industry with respect to effluent, the EPA has issued the effluent determination that basically says, if you are receiving effluent in accordance with this determination, you are in effect authorised to receive it. So it's trying to reduce the level of sort of red tape or green tape around the receipt and the movement of effluent. But if that is relevant to you, we would absolutely encourage you to look at the determination and actually make sure that you are complying with the conditions, because as soon as you don't comply with the conditions, then you're all of a sudden not a place that's authorised to receive it. And the conditions really relate to making sure you've got a process in place to inspect the waste on receipt. So it's important to realise that these duties apply on the people that's sending the waste, but also on the person who's receiving the waste. So the system has gotten stricter, if that's and it's important to be aware that these duties exist. So the way that we encourage clients to think about waste is really...
Can we just pause there? Tim, have you got a question? You've got your hand up.
Yeah, cheers. Thanks for the info so far. I have pulled over too. I guess this is the big topic, this one, because as pig farmers, we have many different systems. Some people might have pigs outdoors. Some people might have deep litter, which is in a shed, but they have litter in there they take in and out. And others have conventional sheds where you produce solids and liquids. I guess then my first question might be around, is there different rules if the liquid gold we produce goes on our own land or goes to someone else?
There will be from a permissions perspective. So that's where in the permission section we talked about the waste solely to land versus waste not to land. So if it's waste solely to land, it's considered a lower risk activity and it only needs a permit, whereas if it's waste that's not going solely to land, it's considered higher risk and needs a licence.
But also, if you're not transporting it anywhere, like on public roads, then arguably the transport duties wouldn't apply either.
So the first thing to do, though, would be to classify your liquid waste, your liquid gold, sorry. So when you talk about liquid gold, are you telling me it's an industrial waste? Are you telling me it's a priority waste? Or are you telling me it's a reportable priority waste? So that's always your starting point.
I believe most of us will say it's designated by the EPA, but I'd argue with them about their definition, but it would come under the industrial waste. And I guess what I would love to leave from here is actually, or so maybe not from here, but in the future from here, is actually have some examples. So if we have a liquid effluent, what does a farmer have to do? If we have a solid a solid form, what does a farmer actually have to do? Because at the moment, that was, I guess, my main aim to come out of this, to actually understand what we actually need to do. And it sounds, because I hear you, what you're saying, we're going to have to get permits or, those agreements, but to actually understand exactly what to do and have a live example, I think would be real helpful for us. And Luke, it might be something VFF has to do as the next step.
So, Luke, what we might just need is a list of what waste we're talking about here, and we can have a look at that.
Yeah, I think that's the best approach. We can put a scenario to you guys, and if you can provide some advice, we can provide it to.
Yeah,
Luke,
and because,
I think from the people on this, 6 scenarios are or 5 scenarios might nearly cover majority of producers. So I think it'll be pretty easy to do, but I could be totally wrong.
Yeah, and I think it will depend on, is it being transported somewhere else, or are you using it on the same site, or, all of those sorts of things need to be fed into the scenario, as well as, well, what type of waste is it, but where is it going, what's being done with it, is it being transported on public roads, and all of those sort of things.
Yeah, but it all starts with an understanding of what product or what substance are you actually talking about. So that's, if we get a list, then that will help us.
Yeah, so this actually probably feeds really well into this diagram about the steps that you need to go through to work out, well, what do I actually have to do? And maybe we could sort of, develop a diagram like this for 4 or 5 scenarios or something.
Yeah, and so this diagram is really getting to the sort of points we've been making, is that if you've got waste, you've got to classify it. If you're storing it, how much are you storing? Volumes are important with respect to permissions, but also, the more volume, the greater the risk. So that plays into your JED and what proportional steps you need to be taking. Are there storage guidelines that you need to be complying with? Then, if you've got priority waste, so that was that middle bucket of medium risk waste, can you reuse, recycle, or identify other alternative ways of disposing of the waste other than to landfill? If that waste is being transported, does the transporter need a permission? Where is it going? Is it going to a place that's authorised to receive it? And then if you're receiving the waste, are you authorised to receive it within the meaning of the legislation? So, we've done whole presentations on waste. Like, we understand that this is a big deal for a lot of people, and we can certainly drill into more detail on this sort of separately to this session if required.
Sophie, you mentioned about the authorised to receive waste. So if a farmer has waste, like Tim was mentioning, liquid gold, and that was being sold as a fertiliser to another farmer, does that farmer then, how do they classify whether they're authorised to receive that, or is that in a contract, or is that going to add another layer of complexity to that transaction taking place? Yeah,
quite possibly. Is the short answer. Sorry, maybe not the answer you want. But it means, in a nutshell, is, do you have the permission that you need to receive the waste?
Sorry.
I was just going to say, we do have a case study later on that might sort of get to some of these points. I'm not quite sure.
Yeah, they're probably not to the level of specificity that I think is going to be required. This sort of presentation is about issue spotting. It's about doing the broad general, these are all the things you need to know. As I said, we've done a whole hour on waste for other clients because it is a big change, and particularly, like, how do you classify it under the new system? We sort of step through that with a bit more detail. But I totally take your point about needing a more specific example. I think if you get us a list, we can certainly try and build that, create some sort of a one-pager around that.
Sophie, I think I can help to answer some of Tim's questions. So in relation to piggeries, if you're depositing the effluent, whether it's solid or liquid, on your farm, you need a permit if you have more than 5,000 animals. If you have less than 5,000, you do not. And then if you're delivering the waste to another person's farm, you have to adhere to the waste determination, which I believe Sophie is going to touch on. Sophie and Jane are going to touch on here. But we'll put together some written examples on that. That's
also in the fact sheet, the reference to the effluent determination. So that's a particularly important document for you guys. And if you haven't read it yet, I would absolutely encourage you to read it. So we might just move on. I'm just conscious of time. Jane will now speak a little bit about contaminated land.
So the important thing to note about the contaminated land, and again, there are new duties. So back in the day under our old Act, if you were sort of sitting on a contaminated site, you didn't actually have to do anything. You didn't have to tell the EPA, you didn't have to manage the contamination or investigate it. It was only if the EPA issued you with what was usually called a cleanup notice that you then actually had to do something about it. And the EPA saw that that was a bit of a problem because obviously if you're trying to sort of purchase a property, working out whether a site's contaminated is one of the things that you'd be looking to do. And it was identified that there was a real lack of information in Victoria about, well, where is the contaminated land? How do you find out about what land could be contaminated if there was no sort of duty to tell the EPA about land that you'd sort of discovered that was contaminated? So a lot of the new duties in relation to contaminated land are designed to provide that information, and then it goes on to a register that enables people to sort of do their due diligence more easily. But there's also a duty to manage, and I'll talk to those duties a bit in a minute. But the other important thing to note about this is that it's not just applying to contamination that occurs after 1 July of this year. So it's historical contamination is covered by these new duties. So the duty to manage applies to a person in management or control of contaminated land. And the duty requires that person to minimise risks of harm to human health and the environment so far as reasonably practicable. So again, you're hearing those words, so far as reasonably practicable, and you'll, cast your mind back to all of those factors that we talked about in relation to the general environmental duty as to how you work out if what you're doing is reasonably practicable or not. And there are sort of definitions of what is contaminated land in the regulations. And it talks about sort of concentrations above background concentrations. But in addition to sort of being above background concentrations, there needs to be a risk of harm to human health and the environment. So just because something's above a background concentration, if there's no risk, then it won't be contaminated land for the purposes of these duties. So the duty to manage, just be aware that there's not actually a requirement for you to sort of obtain a permission or anything. It's a duty that applies to people that are in management or control. It's not an offence to fail to comply with this duty either. So what happens is if the EPA forms the view that you're not managing contaminated site properly, it will issue you with some form of notice, and we'll come back to the sorts of notices that the EPA can issue later on. But you can see there, it's really sort of a continuum of, depending on what your knowledge is at the time, a range of different things that you might be expected to do in relation to this duty to manage. And it includes identifying it, obviously, investigating and assessing, where is it, how big is, for example, a groundwater plume, where does it go, where are the edges, where are the hot spots, for example. Then there's a requirement potentially to provide and maintain reasonably practical measures to minimise the risks of harm. So not surprisingly, that can require you to actually clean up the contamination. But importantly, there's also a requirement that you give information to people who might be affected by the contamination so that they're aware of, what the contamination is, for example, and where is it and how it might affect them. So does anyone have any questions about the duty to manage contaminated land? No. So the other duty is the duty to notify of contaminated land. And again, this applies to a person that's in management or control of contaminated land. But like the buckets that we were talking about in terms of waste, there is a smaller bucket of contaminated land, and this duty to notify only applies if you've got notifiable contamination. So not all contaminated sites need to be notified. It's just if you've got a site that has notifiable contamination. And unfortunately, even though we all sort of made submissions in relation to the draft regulations when they were being developed, if you look at the regulations now, if you do not have a science degree or you're not an environmental consultant, it can actually be pretty hard to work out whether you've got notifiable contamination or not. So there are quite specific definitions of what is and isn't notifiable contamination. It goes through groundwater as well as land contamination, as well as vapor intrusion, for example. So there's a range of different categories of notifiable contamination. You would, if you have doubt about it, you may need to get some assistance from an environmental consultant to know whether you have actually got notifiable contamination. And then that is the category of contamination that you need to notify the EPA of. It is an offence to fail to comply with this duty. So any questions about this duty to notify? No? Okay, so going to the next slide. So there are, and I'll come later on to a number of notices that the EPA can issue, but there is a new thing called a site management order, which the EPA can use if, for example, they need ongoing groundwater monitoring for a long period of time. Then there is this the new tool, a site management order that effectively runs with the land. So if you sell your land, the site management order will bind the people that are purchasing that land from you. And it becomes a statutory charge on the land. So in other words, if you don't comply, the EPA can take enforcement action and recover costs of complying with site management orders against the land rather than a particular person that the order's been issued on. So just be aware that that sort of follows the land and can require that sort of ongoing maintenance or management of groundwater monitoring, for example, or if there's a containment cell for contaminated soil, that might be when they use this site management order. The other thing to note is that the polluter pays principle has been enshrined in the legislation. So if you as a person in management or control of land have to comply with an environmental action notice or a site management or an environmental action notice or these new duties to notify or to manage, and you didn't create the pollution, then there is the ability to seek to recover your reasonable costs of complying with the environmental action notice, which I'll come to in a minute, or these duties from the polluter. So just bear that in mind. That was really all I wanted to say about contamination, unless there were any questions.
Just conscious of time, Jane, we might have to whip through some of these a bit quicker.
Yeah, so the next bit is pollution incidents, which again, it's quite broadly drafted, and Sophie and I have been providing advice that when you get the devil's in the detail and the more that you look at these provisions, the more broadly they're drafted and the more scenarios they capture. But if there has been an incident or set of circumstances, but that doesn't include noise, that causes a leak, spill or other unintended or unauthorised deposit or escape of a substance, and as a result pollution occurs, then that is a pollution incident. And you can see there again that we've got sort of this, I guess, different levels of obligation depending on the level of pollution that's occurred. So if there's been a pollution incident and it's likely to cause harm to human health or the environment, then you've got a positive duty to restore the environment to the condition it was in before the incident occurred. So in other words, you now have an obligation to clean it up. Before, there was no positive obligation to clean up an incident. You might very well have done that as a matter of good management anyway, but now there is a statutory duty to do that. And you can see there in the bottom box that if what the incident has caused is material harm to human health or the environment, not only do you have to clean it up and fix up the environment to this condition it was in beforehand, but you also have a duty to notify the EPA. And then, so the key question then becomes, well, what is this material harm? And it's talking about, well, has there been an actual adverse effect on human health or the environment that's not, marginal or
Negligible.
negligible is the word that they actually use, or what is the nature of the receiving environment? So is the environment that it's gone into of special significance, really? And so, that's going to be sort of national parks or, protected by certain planning overlays that suggest that this is a special place. Or the catch-all is it would cost you $10,000 to prevent or minimise the harm from occurring or to clean it up. So that is the real kicker, I think, in all of this, in that $10,000, depending on the scale of the incident, doesn't get you very far. So be aware that if you're going to spend a reasonable sum of money over $10,000, then in relation to that incident, then you will have a duty to notify the EPA.
Yep. So if you've had an oil spill, if you've had a chemical spill, if the runoff has gone to a place that you didn't want it to go, if the effluent has been spilt in an area that you didn't want it to be spilt, and you need to get people in to help you clean it up, you'll need to start to think about, well, how much has it cost me? If it's cost you more than $10,000, you'll have to notify the EPA.
Yeah. So moving on to notices. So there's a range of new notices that the EPA can issue. The most obviously relevant one is an environmental action notice, which is really the equivalent of a cleanup notice. You can see there that there are a range of other notices. The other thing to note is that the range of people that the EPA can serve with these notices is broader than who they could serve before. So the current owner or occupier of a site, the previous owner or occupier at the time the contamination, for example, arose, can be served, as well as the polluter. So just be aware that if you're owning or occupying a site, the EPA can issue you with a notice, an environmental action notice, if that land, for example, is contaminated. So don't think that, it used to be just the occupier or the polluter, but now it's, for example, the owner. Moving on.
Question, Jane, about the spill, the pollution incident. Does the $10,000 cleanup cost include the loss of product, i.e. diesel spill? Would it include the diesel that you've lost?
I don't think so. It's the $10,000 applies to the steps that you need to take to prevent or minimise the risk of harm, or to clean up or rehabilitate or restore the environment. So I mean, we were sort of thinking that waste disposal costs would be covered, but I don't think just because you've sort of lost money because you've lost your diesel, that's not my understanding of what goes into the $10,000.
No, it's more that if you've had to excavate soil because the spill has gone onto a soil area and you've needed to get, like, it's been a lot of soil, and you've had to incur costs to clean that up.
Yeah. So moving on to the changes to the penalty regime, the takeaway from this slide is that the penalties have gone up. It's also possible for the EPA to issue or to pursue a civil penalty. So it has a lower burden of proof. The penalties are the same as a criminal prosecution, but it's easier for the EPA to make out its case because the burden of proof is lower. So if you're sort of seeing an offence provision in the Act and it says civil penalty provision, that's what that means, is that the EPA can elect to pursue it criminally or a civil penalty.
And
so
the figures on this on this slide are the maximum penalties. So you're not going to get done for $800,000 every time you might not comply with a permit condition. These are maximum numbers.
Yeah. The other thing that just to note quickly is that in the past, the only person or the only entity that could enforce the law was the Environment Protection Authority. There is now a community civil remedy. So if, for example, let's go back to our disgruntled neighbour that hates the odour coming from whatever operation it is, on the basis that that person is a person whose interests are affected, they will be able to apply at court for an order to require something to be done about that odour, as well as for compensation orders. The The big thing about this also is that not only does it give people whose interests are affected that right to go off and to seek to enforce these duties that we've been talking about, but even if you're not a person whose interests are affected, if you've asked the EPA to do something about it and they haven't, and the court thinks it's in the public interest to enable you to enforce the law, then they can make the orders for those people as well. So it is quite a different change to how the environmental laws are enforced in Victoria.
But I mean, obviously that, you know, these things do cost. So if I'm the disgruntled neighbour, you know, I've got to cop the cost of going to court, and I've got to cop the cost of seeking these orders to be in place. So there, you know, there is a natural barrier to some of the disgruntled neighbours out there that are just more interested in making noise than actually doing anything about it.
Now, I'm conscious of the time. I think we'll skip over the review rights. The point of that is if the EPA makes a decision that you're not happy with, there are certain review rights. So either internally or at VCAT. So let's skip over to the case studies. So the first case study that we've got is that a neighbour is going along a road and sees that there's some unusual odours and browny green liquid running along a road reserve, which unfortunately is heading into a nearby waterway. So that neighbour reports this to the EPA. The EPA comes out and notices this liquid is overflowing from a farm's drains, and discovers that the effluent has been discharging into this waterway for over a week. The things to think about, well, if this was generated from a farmer's operations, has that farmer been implementing the general environmental duty in relation to their effluent management system? So have they got systems in place that have identified the risk, implemented risk minimisation measures, trained people in this effluent management plan that's specific to that farm? And do people actually, is there a system in place? The important thing to note is that the fact that it's been going into the creek for a week isn't relevant to this general environmental duty. It's all about, do you have a system in place to stop that from occurring in the first place? What is relevant in terms of the effluent entering the creek is that it will be a pollution incident, arguably. So there has been a discharge to the environment, and that there's been harm to human health or the environment as a result. So there is a duty for that farmer to restore the environment to the state it was in beforehand. So maybe you need adductor trucks and you need to flush the waterway out, for example, after you've sort of sucked out the effluent as much as you can. As well as if there's been material harm, for example, fish kills as a result, then there would obviously be a duty to notify the EPA, but on the basis that the EPA has already gone out and inspected it, then there is no duty to notify them again. So just be aware that if they're already there, they know, obviously. And so in terms of enforcement, have you complied with the general environmental duty? Potentially they could rely on this material harm offence for a 2-year period. Have you notified the EPA if they didn't already know that there's been a pollution incident? And have you restored the environment? Arguably, if you've got a licence that applies at the site, it may also have been a breach of licence condition. So it's potential that there would be fines and an environmental action notice requiring you to remediate if you hadn't already done so. I'm not quite sure if we want to pause for questions or just move on to the second case study.
Jane, there's a question in the chat in regards to how does the civil remedy work for agricultural areas where residential zones are encroaching?
The civil remedy applies everywhere. So in other words, if people whose interests are affected are disgruntled, then they in theory can go to VCAT to seek a remedy if they're not happy with what the EPA has or hasn't done. And anybody in that area can also, if they get leave of the court, if it's in the public interest to do so, and the EPA has failed to enforce, then those people would also have an ability to seek to enforce the law. I don't know that the court's going to open the floodgates, and the reason why it's got to be in the public interest is to give the court that discretion as to when this is a useful exercise as opposed to something that's a vexatious and unmeritorious claim. So there will be that sort of filtering by the court, but that doesn't apply if people's interests are directly affected.
Thanks.
And so we'll just finish on this last case study, which we can build on separately if we need to make it more specific to make it more helpful. But the scenario is that, you know, farmer Alex produces liquid gold in the form of manure. Alex takes it to his customer, Farmer Joe. If there is manure left at Farmer Joe's farm after 20 days, he takes it to another person's farm. Farmer Joe has no process in place to inspect the waste delivered by Alex. And then Farmer Joe discharges waste solely to land, but doesn't have a permission to do so. So we've designed this scenario to touch on a few different things that you need to be thinking about. From Alex's perspective, who's delivering the manure, does Alex have an environment plan for the storage, handling and transport of effluent, which is relevant to the general environmental duty? Does Alex have a system in place to make sure that the waste is going to a place authorised to receive it? So when Alex drops the manure off at Joe's, does he see that Joe is inspecting the waste, and does he understand what's required by the effluent determination to ensure that everyone's complying with that determination so that they are an authorised place to receive the effluent? You know, if Alex rocks up and Joe says, oh yeah, just throw it over there, I don't care what's in it, that's probably not a great sign. In terms of managing the waste, both Alex and Joe need to classify the waste. They need to make sure they've complied with the determination, and they need to make sure that they're authorised to receive it. So that's the managing waste section. In terms of permissions, Alex might need to consider whether he needs a permission to transport the waste. Joe needs to consider whether they need a permission to accept the waste. If they're not inspecting the waste in accordance with the determination, then they may no longer be considered as a place authorised to receive it, and therefore might separately need a permission to make sure that they are authorised to receive it. In this scenario, Joe receives the manure or the effluent and then takes it somewhere else after a short period of time. This might invoke the requirement to have a permission for the temporary storage of designated waste, because designated waste includes animal effluent and residues. So if you are temporarily storing designated waste that is generated at a different site, and you're storing it for less than 60 days, you might need a registration for that temporary storage. And in terms of Farmer Joe, who's using the waste and discharging it solely to land, and you've got greater than the 5,000 animals, so whether that's a combination of pigs, cattle, sheep or goats, then you may need a permit to undertake that activity. So the point of doing these case studies is to really show that, you know, in one scenario or one typical day for a farmer, there could be a variety of things that you need to be considering under the new legislation, whether that's your waste obligations, whether it's the permissions that you now might need under the new system because there are more permissions, whether it's the general environmental duty. There are a variety of things that you need to be thinking about, but that might not mean that there is a significant change to how you conduct your day-to-day operations. You might look at the general environmental duty and say, yep, I've got my environment plan. Yep, I look at that every year and I make sure that it's up to date. Yes, I'm storing chemicals in accordance with the relevant guidelines. When I transport my effluent, I make sure that I put it into the truck in a safe way. And you might be comfortable that you're doing everything reasonably practicable to minimise risk. But it's important to be aware that these things are all out there now because of the new legislation.
And I think I don't want you to sort of sit there going, oh my God, this last case study, it's just all too hard. I think maybe once we've worked through some scenarios and sort of worked up the answers to particular scenarios, hopefully that will help you navigate the particular permissions and requirements around these waste duties, which seems to be the the area of greatest interest, I think. So that was it from us, I think. Sophie, unless you were about to say something
No, I
else.
was going to say, for people that you know that would be interested in aspects of this presentation, Luke will be circulating the recording and the fact sheet so that you can refer to them. And, you know, if you've got additional questions, send them through to Luke and we can certainly help you out.
Thanks, Jane and Sophie. That was, yeah, really interesting. I know I certainly learnt a lot there. There's a few questions outstanding that we'll go away and try and answer before we send out the recording and the fact sheet so that we can give everyone as much information as possible. Thanks, Tim, for putting those scenarios into the chat. I think that pretty much covers everything, but if anyone else has any other scenarios relevant to their farm, let myself or Lyndall know and we can try and get a response. So yeah, thanks Jane and Sophie and everyone for jumping on today, and we'll be in touch shortly.
Thanks, Luke. Thanks everyone for coming along.